I'm pleased to be a volunteer with the Epilepsy Foundation. I have been living with epilepsy since I was about 5 years old, and I am a sophomore at Western Washington University. I am studying exceptionality and disability. Our next speaker is Susan Cass. Susan serves as a staff attorney and director at the Community Inclusion Services Program at Disability Rights Washington, where she works on class action and systematic litigation in efforts to improve supports and services for people with disabilities. In 2016, Susan became an associate director of legal advocacy. Prior to joining Disability Rights Washington, Susan graduated from the University of Washington School of Law. When not working, Susan enjoys running, knitting, and most of all, hanging with her 2 daughters. Please welcome Susan Cass.
Hello, everyone. I'm Susan. Thank you so much for having me today. So today I'm just here doing a presentation about disability rights and how it intersects with folks who have epilepsy. A lot of what I'm going to be talking about today is not specific to disability rights of people with epilepsy, but it's more general. But I will try to talk a little bit about some issues that may be especially pertinent today for this conference. So there are lots of legal protections from lots of areas of law for people with disabilities. So I'm going to try to focus on 3 areas. I want to talk about some protections around employment and protections against employment discrimination, also around education rights, and then lastly around protections of public benefits. So just to get started, show of hands, how many people are familiar with the Americans with Disabilities Act? So this is a piece of legislation that's we've been celebrating for over 25 years now. It has, I think, changed the landscape of how our country thinks about disability, as well as people with disabilities rights to participate in just everyday life. And so employment is a major part of that. We still have a long ways to go. So one of the things I want to just make sure is that we cover what the basic protections are, so that hopefully you won't ever have to use it. But if you or someone you know is encountering any kind of discrimination, you know the basics, so that you can kind of issue spot and recognize that there may be some protections in the law that can prevent what's happening. So essentially for employment, the ADA, the basics is it prohibits discrimination because of someone's disability. So this can apply for job applications, the procedures, hiring, firing, compensation, any other type of employment privileges. So it can be advancement, promotions, those kinds of things. The ADA says that you can't treat someone differently, discriminate against them in any of these areas just because they have a disability. We also have a state law, the Washington Law Against Discrimination, and the requirements under we call it the WLAD, or the Washington Law Against Discrimination. So the requirements under that very similar to the ADA. The job application procedure can't be discriminatory. They can't. It's illegal in the state under state law to have job postings that have any sort of language that would discriminate against people with disabilities, hiring, firing, pay, or other conditions of employment. One of the things that is really important under both of these statutes, and this is one of those things where sometimes you want to get to what was the action that we're trying to stop, what is it that happened that was unfair, and one of the things that we always try to educate people about is that under both state and federal law, people do have to first prove or have evidence that they are someone with a disability, and both laws have their own definitions of disability. They do overlap, and they can, they're not necessarily mutually exclusive, but the way people have to explain, I have a disability, as just a first checkbox is a little different under each law. Both require that there be, the language is impairment, that there be some sort of impairment. So under the ADA, which is the box here on the right, is that you have to have a physical, my right, your left, a physical or mental impairment that substantially limits one or more major life activities, or you have to have a record of having such an impairment, or you have to be regarded as having an impairment. So those are 3 different ways that someone can qualify for protections under the ADA, and it can be all 3 or 1 or 2 of them. Under the Washington law against discrimination, it's also, you have 3 different ways, but instead of having the substantial limitation on a major life activity, the Washington law against discrimination says it is a sensory, mental, or physical impairment that is medically recognized or diagnosed. It exists as a record, or it's perceived to exist, whether or not it does in fact exist. So even if someone is like, I've never been diagnosed with this, I don't have this, if someone is saying, yes, you do, and that's why I'm treating you differently, same with the ADA and the Washington law against discrimination, even if the person themselves doesn't believe that they have a disability, if the person treating them with discrimination believes that there's a protection there. Basically, under these definitions, which are both intended to be very broad, the ADA was amended in 2008 to make it very explicit that Congress intended the definition of disability to be very broad. I would think most people with epilepsy should qualify for protections under both of these statutes. But it's still important to explain and allege as if you're going to be invoking your rights, that in addition to here's my diagnosis for an ADA, explaining how it limits life activities, or showing a record or being regarded as. One of the things that has come up as a question throughout different cases and across the country is, well, what's the effect of medication? So what if I have a condition, but I'm getting treatment for it, and with treatment, it's effective, and my life activities are not substantially limited? What does that mean? So one of the things that the ADA 2008 amendments did is it made very clear that the condition is evaluated without regard to what treatments or medications or the effects of that. So but for this treatment or this medication that you're taking, your condition would be substantially limiting on a major life activity, that qualifies. So the only thing is glasses. So if someone is saying, without glasses, my vision is impaired, if your vision is not substantially limited with glasses or contacts, then that does not qualify as a disability under the ADA. But if for a condition like epilepsy, if your symptoms, you're not experiencing them and they're not limiting your activities, but it's only because you're taking a treatment or a medication, then you're not disqualified from protections under the ADA or under the Washington law against discrimination. The other question could be the opposite, where maybe what that people are experiencing, and this probably would not come up separately, but if, for example, your condition maybe wouldn't fall as a substantial limitation on a major life activity, but in order to treat this condition or to keep it from getting worse, or the medications that you're taking, you're experiencing side effects, and those side effects are impacting a major life activity. It could be with your sleep, it could be with various other symptoms that you might be experiencing. It's come up as whether that can qualify as a disability, and in a lot of cases it can. There are 2 requirements that courts, I think the Second Circuit is the only circuit court decision I could find, but we're in the Ninth Circuit, but it's still persuasive here. So what I'm typically finding when I did some research on this is that most courts say that if your symptoms from the side effects would otherwise meet the definition of an impairment, in other words, it would otherwise substantially limit a major life activity that you have, and you can show that this is treatment that's required, the language is the prudent judgment of a medical professional, and that there's no available alternative that is equally efficacious and lacks similarly disabling side effects. I think in most instances, most people, that's going to, if you choose to take the medication, you're going to want to make sure it's something that your medical provider is recommending. And also, I think if there's significant side effects, most people would want to know, is there something else that we can do in the alternative? So this is not a very high bar or narrow bar to meet. But the one thing to keep in mind is that some classes of medications, I did find some cases here and there where certain classes of medications could be disqualifying. So if someone's taking a heavy-duty pain medication, for example, we found cases where the court said that employers were entitled to say that they were not qualified to serve as like drivers, for example. So you know, the theory being that, okay, well, someone is regarding this medication as having a disabling side effect. I don't think it's disabling, so therefore that should be a protection. Courts have not gone for that argument. So just to be aware that if you are taking certain classes of medications where under policy an employer might say for safety reasons you can't be taking this medication and do this job, that has been allowed by courts. So one thing that the ADA does provide for, and the Washington Law Against Discrimination, is that if a person can do a job, but they need some sort of modification of the job or reasonable accommodation, the employers, if it's not a fundamental alteration or unduly burdensome, employers have to provide that. There are infinite number of reasonable accommodations that could apply for people with all sorts of conditions. So these are just some categories. Job restructuring, if you can do the essential functions of the main job, but it may be that you do them in different ways or in different configurations. Big one is work schedules. If there's no need for you to be at work from 8 to 5 with a 12 to 1 lunch hour break, and those hours are really, really difficult for you, and it would be easier to flex your hours or to modify your work hours or work part-time, that can be seen as a reasonable accommodation. If there's another position that you're qualified for and it's vacant, that can be a reasonable accommodation. And then lastly, sometimes people can do the job with modified equipment or assistive technology, and if it is not unduly burdensome, employers are required to provide that. I did include a link. If you guys aren't familiar with this, askjan.org. There are tons and tons of resources and examples and samples for reasonable accommodations, and I think they also have a technical assistance hotline. If you're just like, I don't know, I need help brainstorming what would be a reasonable accommodation for this, that can be a very good resource. It's right down here at the bottom, Ask Jan, Jan. JAN stands for the Job Accommodation Network.org. Another question that comes up for folks is, do I have to tell my employer? Sometimes I've talked to people where they actually feel like guilty for not telling their employer, or their employer insinuates that they're somehow hiding or being untruthful. So I wanted just to clarify what people's obligations are around disability disclosure, which I will just say is a very personal matter. There's no right or wrong answer on whether you should or shouldn't. And so I would say that here are the two things that I just want people to know about their rights and their obligations. So employers, before they offer a job, they cannot ask any questions that would lead to any information to disclose a disability. So they can't ask about what kind of medications are you on, or have you ever had reasonable accommodations in your prior jobs? Anything like that would force you to disclose the presence of a disability. Before a job offer, employers are not allowed to ask this. And applicants and employees do not have to disclose their disability unless they're asking for one of these. So if you feel like, I can do my job just like everybody else in this job, I don't need any changes, I don't need reasonable accommodations, there's no obligation to disclose your disability, and it's not appropriate for your employer to be asking. So essentially the bottom line is, this is pretty simple, that if a person has epilepsy, they can't be denied employment or denied employment benefits on the basis of their disability, on the basis of their epilepsy. Employers can't say, because you have this condition, you can't have this job, or we're going to not give you the promotion, or your pay is somehow different. But the two things you have to show is, first of all, as we said, in addition to demonstrating you have a disability, is that a person can perform the essential functions of the employment position. Or under the Washington Law Against Discrimination, this is, I guess it's the same requirement, but they just phrase it differently, that the condition does not prevent proper performance of the work. And this is keeping in mind with a reasonable accommodation. So if someone can say, I can properly perform the work with a reasonable accommodation, or I can perform these essential functions with a reasonable accommodation, employers can't discriminate. If hopefully you don't have to use this, and you can work out any issues that you have without having to invoke the complaint process. But there are protections. Both state and federal law have commissions that are specifically designated to investigate complaints of discrimination and take enforcement actions. For federal law, so that's the ADA, so any complaints under the ADA where you're saying you have a condition that is substantially limiting a major life activity, that would be with the EEOC. That's for people who work for employers with at least 15 employees. Washington Law Against Discrimination, it covers any employer with 8 or more employees. They have to be operating at least 20 weeks of the year, so some of the really short seasonal businesses might not be qualified for an EEOC complaint. There are some exemptions, for example, religious organizations that the EEOC and the Human Rights Commission might not have jurisdiction over. And then for both EEOC and Washington Law Against Discrimination complaints, they must be filed within 180 days of the last date of discrimination. And here's the links down here at the bottom for, you can Google and just find them, but if you want the links, here's the links to these agencies' websites. So I want to switch gears, talk a little bit about education rights, which are actually, the first set of education rights are very similar. They overlap with the employment rights. This is under Section 504 of the Rehabilitation Act, which was kind of the precursor to the Americans with Disabilities Act. So it basically does the same thing. It says students, it's not just students, but in this case for education, students or people who are receiving any kind of services from a federally funded entity, so that would be schools, have the right to be free from discrimination. So Section 504, just like the ADA and the Washington Law Against Discrimination, it prohibits exclusions that are based only on someone's disability, and it requires reasonable accommodations. The IDEA is another source of rights for students with disabilities. Has anybody, who here is familiar with the term FAPE? F-A-P-E? Okay, so FAPE is a pretty well-known term now. It stands for Free and Appropriate Public Education, and that's what the IDEA says, is that students with disabilities are entitled, just like all other students, to a free education, and that education should be appropriate to their needs. What that means is that it has to be provided in the least restrictive setting that's possible. So if a student can be in a regular school, a regular classroom for any part of the day or all day, the IDEA requires that students be educated in the least restrictive setting that's appropriate. And then also the IDEA requires two things, which are special education services and related services. One of the things just to keep in mind, this is not wildly different from the other definitions of disability, but every law, for some reason, Congress and legislatures love just to write their own definition of disability. So IDEA has its own definition of disability that's slightly different than the ADA and the Washington Law Against Discrimination. So here we go. Here's the IDEA definition, that you have another health impairment that's you have limited strength, vitality, alertness, including heightened alertness to environmental stimuli that results in limited alertness with respect to the educational environment. That is, 1, due to chronic or acute health problems, and it specifically calls out such as epilepsy, and adversely affects the child's education performance. So under Section 504, the definition of disability is the same as it is for the ADA. But for IDEA, if you're going to be invoking the IDEA rights for FAPE, this is the definition. Huge overlap, so it shouldn't be an issue, but just knowing that there's different elements. So talking a little bit about what are some special education services. The definition is that they, first of all, have to be free, no cost to the parents. So parents can't be told, we'll provide you with this service, but you gotta pay for it. And they have to be designed to meet the unique needs of the student. This includes, one of the biggest areas is specially designed instruction, which means you have to, sometimes that can mean adapting or modifying the content of the curriculum, how the curriculum is delivered, the methodology, the setting of the instruction. Again, The whole idea is that it can't be a cookie cutter, one size fits all. It should be designed, the instruction should be designed for the unique needs of the student. And it should ensure access to the general curriculum and meeting the education standards. So school districts under the IDEA are obliged to provide educational services with the goal of, we want you to learn everything that every other student is learning in this school. And if we have to teach in a different way, that's what the IDEA requires. Related services are similar in that, but these are maybe not direct education services, but these are other supportive services as required to assist a child with a disability to benefit from special ed. So if a child would benefit from the special instruction, but they need other additional services that will enable them to attend school or to participate in the classes, some of the commonly requested related services might include like health services, for example, nursing or medication administration, specialized recreational services, counseling. I didn't put it up here. Another common one would be specialized therapies like occupational therapy, physical therapy, speech therapy. And also, as we were talking about, these can be education accommodations, can be 504 reasonable accommodations, or they can be part of the specialized instructions or the specialized services. So they all kind of fall under the same bucket, but these are just the types to think about. Modifying the program requirements. So, for example, if a program requirement is, to pass a swim test, maybe that needs to get modified. Or a memory-related task, if memory is being impacted by a person's condition, maybe making the task so it's not so based on recalling, but it can be more comprehension-based. And then modifying deadlines and time constraints that might be difficult because of a disability. Other accommodations could include, of course, access to treatment and medication. So if, the rules of the school are, we only allow students to have this much time in between these classes, but medication schedules, they need more time or they need to get out of a class in order to go take a medication to stay on schedule. Those kinds of things, schedules need to be modified so that students and young people can access the treatment on time. Also, training for teachers and staff. This includes transportation personnel. That can be a reasonable modification or part of a plan, is that the adults who are responsible for students are aware of a student's condition, and even if they maybe don't know exactly about this student, that they receive education about epilepsy so that they can properly intervene and provide appropriate responses. And then environmental modifications also, if there are certain things in the environment that are exacerbating someone's conditions or symptoms, those can be requested to be modified. A common one is lighting, to have full spectrum lighting instead of the fluorescent. And then also providing, sometimes people would benefit from having a rest area or recovery area with lower stimulation, and that can be something that can be requested. So, I'm sure raise your hand if you know what an IEP is. Yes, IEPs, we all know, are individual education plans. Here are some elements that are in an IEP. This is not exhaustive, but this is just kind of a quick checklist of things that should go in an IEP. First of all, the IEP should articulate what's the current status. So how are we currently performing? So it's current academic achievement and functional performance, and how disability affects student involvement and progress in the general education and curriculum. So just a basic statement and description, a basic statement and description of a student's current functioning and what they need. But the other thing, the more important part, I guess both are important, but the part that I think is really key is that the plan doesn't just stay satisfied, well, this was the status quo, this is what's going on, but that there are actual measurable annual goals. And the key word here is measurable. A lot of times we see goals not just in IEPs, but just in plans across the board where, it's pretty subjective on whether anybody's making progress or how much progress. So these should be measurable goals that are pretty easy to assess whether we're making progress, because the idea is if you're not, that you can change the plan. And this should also include academic as well as functional goals. And then next, of course, is that the IEP should talk about the progress towards meeting the goals and how they're going to be measured. So how the child's progress towards meeting the annual goals will be measured, and when these periodic progress reports will be measured. So these are annual goals, so we don't want to wait a year before we say, wow, we didn't really get anywhere near that. So this should be measured, and depending on what the goal is and depending on, the student, the appropriate timing could be different and how you measure that. And then what's our timeline? When are we going to begin services and modifications, and how long do we think we'll need them? And then, of course, we want to include a description of the services, the related services, and any supplementary aids and services, as well as the modifications. These are the reasonable accommodations that we were talking about, or modifications to the instruction. So program modifications, testing accommodations, school personnel support, training, and these modifications, of course, should all enable a student to advance appropriately towards attaining these annual goals. And then lastly, if there's going to be any segregation where services or instruction is going to be provided separately from other students in the school, the IEP needs to explain that. The extent, if any, to which a child will not participate with non-disabled children in the regular class and in extracurricular and non-academic activities. So one thing, I'm sorry about the typo here at the bottom, but if your child or you're a student and you qualify for both Section 504 and the IDEA, you can just put it in the IEP, all of the reasonable accommodations. But if it's only, you don't need specialized services, you don't need specialized instruction, but all you're asking for is some modification under Section 504, you can do what's called a Section 504 plan. So just to kind of clarify the difference between those, an IEP can include a Section 504. A Section 504 is for people who might not need IEDEA services. Again, I hope you don't have to use this slide, but this is if you're not able to resolve issues. Discrimination complaints can go to the Department of Education. This is a federal agency that enforces Section 504. It's similar to the EEOC in that it needs to be within 180 days of the last date of discrimination. And then our Office of Superintendent of Public Instruction, also known as OSPI. So that's a state agency. I didn't put it in here, and this is my mistake, so I apologize, but OSPI will take discrimination complaints as well. So you can file both discrimination complaints with OSPI, or you can also file what's called for a due process hearing. This is for an individual student who disagrees with their IEP. For example, they might be asking for a service or a specialized instruction that the school is saying, no, that's not necessary, we're not going to provide that, or a reasonable modification, or it could be placement even. Maybe a school is trying to place a student in one setting and the student is saying, no, I would rather be in this other setting. Any kind of challenge to the IEP would be a due process hearing, and so that's about FAPE. And then these should be within 2 years of the allegations. So it could be, sometimes, this could be something, I haven't seen cases where it's gone that far out, but this is a little bit more lenient on time. And then the next one is OSPI will take complaints for a citizen complaint. This can be by anyone. It doesn't have to be on behalf of a particular student or by a student. Anyone who's witnessed or seen or observed violations of the IDEA. And we also have a state special education law that I didn't go over for today, but any sort of special education violation can be reported to OSPI as what's called a citizen's complaint. And these need to be done within 1 year. So the next set of slides, they don't quite overlap as much, but hopefully more overlaps with the first set with employment. But one thing that a lot of people do call our office about is if they have questions about, if I do go to work and I am able to, get more pay or a raise or advance in my career, how's that going to impact my public benefits, especially if we're in a trial period. So there are some supports I just wanted to make sure everyone was aware of. If you are receiving Social Security benefits, excuse me, and this is under the Ticket to Work and Work Incentives Improvement Act of 1999, which provided Um, um, oh, is this one? I might. Sorry about this, guys. So it includes 2 areas of supports for people who want to pursue employment or advancement in their employment. So they have more choice for, and this has been around for a while, so it's not that new, but they have, it's not new at all. But in 1999 is when they created more choice for vocational employment support vendors, so that people could get job support or job coaching. And then also they created under this act Medicare purchase options and Medicaid buy-in. I don't have a lot of details on this, and I'll get to how you can contact us for more information. But we're happy to help you pull information about that if you have questions. But just know that there are some ways where if your income would otherwise disqualify you from just basic Medicare or Medicaid, there might be some options for buy-in that would be more affordable. The other thing is specific to beneficiaries who receive SSI. One thing, people may be aware of this, but a lot of times, the income limits look pretty severe, where you think, oh gosh, if I work at all or get any sort of raise, I'm going to lose all my benefits. And one thing to just keep in mind is that for SSI beneficiaries, that a lot of your earned income is going to be excluded from what is determined your total countable income. So it's called the earned income exclusion. And basically, first off, $20 off the top goes away, and then an additional $65, and that's $20 of any income. So if you're getting, earned income plus, you're getting support from somebody, and it's not earned income, or it's income from investments, for example, $20 of that goes away, then $65 of earned income, and then whatever's remaining, half of that goes away. So the example here, and you can do calculations, here's a link for a tool to calculate. The example here is that if a person is earning $1,000 in gross wages per month, and you take away $20 and $65, that leaves them with $915. Divide that by 2, so what their countable income is actually $457. So if this person were receiving SSI alone, in 2020 they would be getting $783 a month, but with these wages, their reduction would not be the full $1,000, because that looks like, okay, that's just going to cancel out all of my benefits. Their actual monthly income would be about a little over $1,300 a month, $1,326. The other thing to keep in mind, that in addition to those just exclusions that apply to everyone, there are ways to save money, because it might seem like, well, that might be enough to live, make ends meet, but how am I ever going to save to get ahead? I have plans, I have goals. So this is a benefit that's called the Plan to Achieve Self-Support, and this is basically a way to shelter your income so that you can save it for your future. So what you'll have to do is submit what they call a PASS plan, and it has to say, what is your work goal? What is it that you are hoping to achieve? And that work goal has to be something that you can say will lead to more financial independence. So you don't have to say that this is going to make it so that I never have to use benefits again, but if you can say that it will reduce your reliance on public benefits, and it's a work goal, it's totally fine. And then you estimate, how much is this goal going to cost me? And how long is it going to take? So you estimate the cost, and you can say, for my total countable income, we're not going to count that. We're going to shelter this amount that I need to save for this goal, so that you can't count that against me for my benefits. And then, of course, the SSA requests a timeline for how long is this goal going to take. Some examples of things that people have used PASS plans to save for would be like tuition for training. So if you want to take like a web design certification class, and it's like $5,000, and you want to save towards that can totally count. Transportation, if you need to, I need to modify my car, or get I want to buy a vehicle that's accessible, transportation or bus passes. Assistive technology that you need to purchase in order to achieve your goal, you can save towards that with your income, and it doesn't count against you. Business startup costs or equipment and supplies. So I read lots of past plans where people wanted to start their own business. They had a special skill, and being your own business owner gives you a lot of flexibility. You don't have to ask for reasonable accommodations because you just build your business around yourself. And so I did see quite a few examples of people saving money towards starting up their own business. And so that they could acquire more savings without it counting against them. Here is a link that I put under the little examples here. This has a whole bunch of past plans that have been successful that people can read if you want to get ideas or see, compare any thoughts that you might have for work goals. Just in general, also, this applies for SSI and SSDI beneficiaries, employment-related work expenses. So these are, if you have expenses that you can't get reimbursed with your insurance or Medicaid for, that you need to spend to go to work, and it's related to your disability, like other people without disabilities don't have to buy this or pay for this, and I can't get paid back by any other resource, this doesn't count. You can exclude this from your countable income. So this could be medical care, could be the cost of having a service animal, transportation, medical supplies if it's not otherwise covered. So this is another way that, even more than just the standard deductions that we were talking about a couple slides ago, even more can be not counted towards your total countable income. Also, sometimes people have concerns about other things, like what if I have a great job, I think if this works, I'm not going to need Social Security benefits anymore, but I just don't know. We don't know. There is a trial work period and unsuccessful work attempt protections, or basically employment for the unsuccessful work attempt, employment for less than 6 months doesn't count towards the disability onset date when they're determining your eligibility for SSI or SSDI benefits. So if you do end up, not using your benefits and you're reapplying, or you're applying the first 6 months, or if it's 6 months or less, and they're looking at when did you acquire your disability, that doesn't count. And then the trial work period for SSDI benefits is up to 9 months. So you can work up to 9 months with full SSDI benefits before that goes away. And then for Medicaid, SSI beneficiaries with disabilities can retain coverage if I think earnings can't exceed $33,120 in some circumstances. And again, if you're worried about losing your Medicaid, give us a call, because this can get very complicated very quickly. But in general, gives you kind of a ballpark that this is up to the amount that you can earn, in some cases even more, and still qualify for Medicaid benefits. You can get help, like I said. This can get very complicated very quickly. I'm just kind of giving you the quick and dirty so that you can start issue spotting and thinking of questions. But if you want more detailed help, DVR is a resource, or you can go to what's called a Work Incentive Planning and Assistance Program, a WIPA. And if you're in... I should have done it the other way around. If you're in a southern county, Pacific, Lewis, Waukegan, Cowlitz, Clark, Skamania, Cliticac, Benton, Franklin, and Walla Walla. So in the south part of the state, the Plan to Work is the WIPA for you, and I've included the phone number, or Plan for Work. Plan to Work is for all other counties. So King County, and I'm not going to list all the other counties. All the other counties that are not southern border counties are covered by Plan to Work, and their website is plantowork.org. So our office, Disability Rights Washington, we receive what's called, we receive a grant under what's called the Protection and Advocacy of Beneficiaries of Social Securities Act, PABS. What this does is it enables us to provide advocacy support to people who are beneficiaries of Social Security, or I'll go over the eligibility, but who are seeking employment and experiencing barriers to employment. So the eligibility is you either have to currently be an SSI or SSDI recipient and under the age of 65, or you can be a former recipient. You have received but lost SSI or SSDI due to work earnings, but you're still entitled to Medicaid or Medicare. And you either are seeking help with a vocational rehabilitation or employment service, so it might be that you're having trouble accessing one of those employment networks we were talking about, or job supports, or any other sort of barrier that you're experiencing with obtaining or maintaining or regaining employment. So all of those rights that we were talking about with education rights and employment rights, if the impact is that it's a barrier to employment, either now or in the future, this can be something that we can provide assistance for under our PABS grant. Disability Rights Washington is what's called a protection and advocacy system. We have, I think, more modalities in this. These are the main ones that we do under PABS. We do training and outreach like today. We provide technical assistance. So if you call us, we can schedule an appointment for you. Sometimes we can get you in right away if we have an open slot, but we will at minimum schedule an appointment for you and help figure out in more detail issue spotting and providing you with some information and resources that we think might help you decide how you want to proceed. Sometimes things are get pretty complicated, and it might be that we need to investigate. It might be more than what technical assistance can provide. If it's something that falls under one of our priorities, PABS is a big one that is a major priority for us. We can do investigations. We can also go out and monitoring work settings. We've definitely done that with folks who maybe there might be employers who have a lot of employees with disabilities and people have issues just more systemically. We might use our monitoring or investigation for that. And then, of course, if there's individual cases or systemic cases, we can provide some representation, legal representation. There's a lot of resources out there. So here are just some additional resources that might be helpful for folks. This one was the EEOC has a good publication specific to epilepsy in the workplace. Questions and answers about epilepsy in the workplace and the ADA. There's also resources if you're a college or university student. Epilepsy.com has some good resources. I won't read the whole web address there, but that's the rights of college students with disabilities. Also, there's it's a old, but I think it's fairly good still, article that rightslaw.com has done. They are really kind of the special education experts. And so I would recommend this publication is just a manual. It's a great resource for students. The legal rights of children with epilepsy in school and childcare. And then lastly, the slides about protections for public benefits. There's a website on Social Security's website. There's actually a web page that has a lot of resources if you have questions about your rights under Ticket to Work. If you have questions, feel free to call me. I think we have maybe a couple minutes if there's specific questions.
In terms of the 504, could you expand on the definition of reasonable accommodations?
That can be tricky. Reasonable accommodations, they have to be necessary for the student, and this would apply for employees as well. If you can show that this would enable participation or me to do the job, and you're a qualified person with a disability, and with these accommodations you could do everything, you could participate, then it's the burden of the defendant. So that would be the employer or the school district to say why it's unreasonable. So this can get a little tricky, and it's not necessarily something, as lawyers, it's not something that we can just say as a matter of law, by definition, this has to be, it's kind of case by case, and it can depend. What might be reasonable for one school district might not be for another, same by school even. So you're looking at the entire program, and reasonable accommodations is really looked at in context. But the important thing to keep in mind is that it is the burden of the school district or the employer to say why it's not reasonable and why it's unduly burdensome on them. I don't know if that's helpful. It's not a strong definition, but it's a good thing to kind of think about in advance, thinking about it from the other point of view. Oh, one more thing. Two, to keep in mind that generally school districts can't just say, no, that's unreasonable. It's too much money. Money is not, I mean, it can be, but it's not always just it's not dispositive. But there's a requirement to do what's called an interactive process where they need to work with the individual requesting the accommodations and offer something else. It should be a negotiation. It's not just up to someone to keep asking, well, what about this? What about this? And just getting told no, no, no. They need to come back with an alternative if they're going to say no.
I have a quick yes or no question.
Okay, I don't know. It'll probably be, it depends.
4 is only for 5 years old school age, right? It's not early childhood, it's 3 to 5?
504, I don't think it's based on age. It's based on whether the entity gets federal funding. So if it's if the agency or the school district is getting federal funding for those, 504 applies. They can't discriminate against anybody who would benefit from their services. Okay, thanks.